In Pasco County, Florida, the sheriff's office thought it had a great idea. Make lists of who might commit crimes in the future and hound them and their families until they end up in jail or move away. Under Pasco's so-called intelligence-led policing program, hundreds of people, many of them minors, were deemed prolific offenders based on a crude algorithm and subjected to relentless nighttime visits, citations for minor code infractions, and other harassment. So IJ sued.
4 Pasco County parents are suing Sheriff Chris Nacco over the department's intelligence-led policing. The plaintiffs say the program is violating their constitutional rights, leading to what they say is harassment at their homes and what they call bogus arrests. The plaintiffs want a judge to stop the program and are now represented by the nonprofit Institute for Justice.
In December, we secured an agreement that will end the program for good and get justice for some of its victims. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely and IJ attorneys Ari Bargil and Will Aronin. This is Beyond the Brief. So Ari, what was the so-called prolific offender program in Pasco County?
Sure. So the Pasco County Sheriff's Office deployed a crude computer algorithm to determine whether they thought somebody in their county was going to commit future crimes. They did this by assigning a score where you got a certain number of points for a number of things: past criminal activity, having been in a police report, even being a victim of a crime got you a certain number of points, and they scored it out. And then they would have a group of quote unquote analysts who would review those names and those scores and decide who they thought was most likely to commit future crimes and therefore merited additional police scrutiny.
So once you're on the list, what happens to you?
It's not good. So once you got on the list, you were therefore targeted for additional, not just enforcement, but generalized scrutiny. You didn't need to be suspected of a crime, and certainly they didn't believe that they needed a warrant to go into your property. But once you were on the list, that's exactly what they did. They would make routine visits on a daily or sometimes more than one time a day basis. And during those visits, they would bang on doors, look in windows, and demand to see whoever was in the house who was on their quote-unquote list. This went on for a period of years. They did this at all hours of the day without any regard for whether the person who they were searching for, the quote-unquote prolific offender, was actually suspected of doing anything wrong.
So, is Donnie here? Is Donnie home? Hey, Donnie home?
I'm looking for Donnie.
Is Donnie around?
We're looking for Donnie. You know that, right?
Hey, morning, Donnie. How you doing?
So what kinds of people get caught up in this? If it sounds like at first kind of reasonable, oh, people have committed crimes in the past, we're going to check on them, like maybe there's something that's not totally insane about that, but this goes way beyond that.
That's right. Very sadly, most of the time, the people who were on the list were children. And I think that was by design because, in their minds, they were helping prevent people from becoming more hardened criminals by going after younger people who had done trivial things. That's in fact not how it works. And what they ultimately accomplished was getting a lot more younger people into the system at an earlier age. They were arresting people for essentially non-compliance with the checks. And when they'd come to houses, if they found the slightest, in their mind, bit of evidence of criminal wrongdoing, they would do things like take kids to juvenile detention, where they would spend up to 3 weeks at a time missing school, and then drop the charges against them. So this went on for a pattern of years. It happened to all of our clients and their children. And in many instances, it resulted in profoundly negative consequences that could have easily been avoided were they not the victims of this scheme, including missing so many days of school as a result of spending time in juvenile detention on bogus charges, that they were forcibly withdrawn basically from school. Another way of saying that they were kicked out.
Well, and it sounds too like it's a self-perpetuating system, because once you get on the list, then they come by and they inspect you more, and then they find more stuff that they can get you on, and then that continues to keep you on the list moving forward. It's almost like Minority Report meets Broken Windows policing and this kind of dystopian future.
That's exactly right. They really had two basic goals when they were coming to people's houses. The first was, let's see if we can find some evidence of some sort of wrongdoing or essentially trump it up.
Shannon County Ordinance violation.
Accumulation of junk and debris?
So thinking, right?
What else they got? I don't know. Piece of fence.
And if they couldn't do that, if they couldn't find some reason to arrest you, if they couldn't find some reason to cite you, then they would just harass you and intimidate you. Because, as I was saying, the second goal of this program, failing to find a basis for an arrest, was to just get people to leave the county. They weren't actually trying to accomplish anything
I see.
In the traditional law enforcement sense. It was either we're going to find a reason to arrest them or we're going to intimidate them into moving out of the county.
And the way that they were harassing people was also, sort of lots of fines for kind of harmless code violations and things that we would more traditionally see in sort of a fines and fees case context, right?
That's right. They weaponize their code enforcement department. Typically, in any municipality, you're going to have your police who do traditional police things, and then you'll have a code enforcement department that has civilian code enforcement officers that write citations as needed for whatever violations, some big, some small, and that's another podcast. But here, the Pasco County Sheriff's Office brought the code enforcement department under its wing, subsumed it essentially, and had a sworn law enforcement officer, deputy, who was tasked with enforcing the codes. And not surprisingly, that person spent most of their time focused on issuing code violations to prolific offenders and their families. And so, as I was saying before, with the goal being to bring charges against people or intimidate them into moving. One of the ways they were intimidating people into moving was through the use of code enforcement citations. If they went there and they couldn't find another reason to arrest you, or if they sensed the slightest bit of noncompliance with their demands, they would then call in their code enforcement guy who would walk around the property, sometimes going on the property even without a warrant, to find code violations and write people up for them. That would require you to come into court, and that introduced a whole slew of other problems.
Should I start writing citations?
His dad's in there.
Well, write it to him.
Yeah, absolutely.
This one is for having the boats, trailers. They have to be on one side of the property. You can't have them on one on each side of the property. This one here is the address. That light is covering up that address for overgrown. The grass underneath and on the side and the back of the house is over 12 inches.
And it's not just Ari saying that they were trying to get people to move away. This was the sheriff's own paperwork. In the annual review paperwork, year after year after year for these code enforcements, you'd see them saying that my proudest achievement this year was getting this prolific offender's mother kicked out of her house and evicted, and she sadly didn't move out of Pasco. The next year, one of the witnesses we were going to call said, this year I successfully got 13 people evicted from their homes. The next year, 15 people. Then he was promoted and then the person after him, next year, I successfully got people promoted or got people evicted. This is what they were measuring. They wanted to kick parents out of their homes to target their children.
And this is all borne out by the hundreds of hours of body cam
I was about
footage.
to say, it's not just paperwork. We also have body camera footage. What did that show?
So the body cam footage was profoundly disturbing because it captured not just what they were doing to our clients and to people throughout their community, but the internal conversations that they were having about how do we get this person? What can we cite them for? What's a charge that we can put on them? Where they're huddled together, 6-8 of them at a time, trying to figure out what the best way to inflict pain on a given property owner would be. And in many instances, it was calling in the code enforcement specialist who knew the municipal code inside and out and was able to weaponize it most effectively. And there's video of them going onto our clients' properties with tape measures, finding little patches of weeds and measuring them and saying, you've got an overgrown lawn, you've got grass that's over 10 inches in height. And things along those lines. Oh, your house numbers are slightly obscured by your front light. That's a citation. You've got a trailer on the south side of your property, but it's got to be on the north side of your property. It goes on and on and on. There was a hurricane and there was some debris that was set to be picked up by the bulk trash pickup later that week. She got cited for having trash and debris in her front yard. The list of potential code violations is incredibly long. And I guarantee you, if you were to go to any house in Pasco County or my house or your house for that matter, you'd be able to find one. And that is exactly what they were doing.
And then the body cam footage, you would see, like they would go to a parent and say, what we're really looking for is for your kid. And when we say kid, we're talking about 12, 13, 14-year-olds here. What we're really doing is we're trying to find things on little junior over here, and maybe if you help us out, well, maybe we can help these code violations go away. They were saying the quiet stuff out loud. They were finding people, threatening them with thousands of dollars of fines, court dates, and then saying, we can help you go away as long as you give us.
If you rat out your kid, then we'll get rid of this fine.
And if you miss your court date, guess what? Warrant for your arrest.
Okay, Tammy, I'm gonna leave your citation in the door. Just make sure you make the court date, or else you're gonna have a warrant.
So we had the parents getting arrested for missed court dates.
I just don't understand how these kids got on this list in the first place. I know we talked a little bit about.
It's okay.
Yeah, it's kind of blowing my mind. I mean, it sounds like this algorithm had a lot of different potential factors that went into it. One of them was just being a victim of a crime, which in and of itself is just kind of a crazy metric to use about who might be a future offender. But do you have any details about how the algorithm put children on this list?
So yes and no. We deposed their expert, or I shouldn't say that their expert, but the person who devised this program, or at least was tasked with writing the software. And what was evident was that there are two phases of this process. The first phase is the one that you kind of just described, which involved them, assigning scores and coming up with a list of their top, 100 or 200 potential prolific offenders. Then there was a human element. So, part of what they were arguing all along was, hey, this is just computers. There's no prejudice involved here. That's just not true. The second phase of this was for them to go through this with their quote unquote analysts and decide who the people were who they were going to focus on. That is, there's less known about what that process exactly looked like, but you can imagine that when two people get in a room and decide who gets on a list and who doesn't, there's going to be some arbitrariness and some prejudice that gets introduced.
This sounds like taking, somebody who's made some mistakes and kind of reacting in a grossly disproportionate way. Like, how do you think about that? Will, you have a background in sort of defense attorney stuff. Like, does this seem recognizable to you, or is this really extreme?
So I take the point, and some of the kids who got wrapped up in this definitely had run-ins with the law. A lot of things for maybe possession of marijuana or really like minor level property crimes. And I don't think you could design a program that's more likely to take a kid who is beginning to hang out with the wrong crowd and doing some dumb things and force them into a really bad situation. So you're taking a kid who might have, let's say, possession of marijuana. Now you're coming back to his house daily or multiple times a week. And if there's anything late, curfew violations, very small, ticky-tacky things, you throw him in juvie for 21 days. Okay, let's say maybe he warranted that. That means this kid is also missing 3 weeks of school. You miss enough time in school, you get effectively expelled or put into an alternative school. You get out, a couple of days later, they come back, they're asking you more things. You give them attitude, or the parent saying like, hey, last time I spoke to you, you threw my kid in jail for 21 days for more. Oh, now we're going to give you code violations. It's taking small, little ticky-tack things, maybe even on someone who deserves some more scrutiny, and then putting them into a system that there genuinely is no way out of. You're going to end up like throwing people in jail. It's not a good system.
Yeah,
I don't think you could design a worse one.
It's pretty counterproductive even on the, you said they have all of these eviction goals and things like that. Somebody who's kind of toying with kind of criminal behavior, kicking them out of their house doesn't seem productive or helpful to that situation, right? Like, you're not making anything better.
Yeah, no, it's not helpful when a troubled kid is there. You can't evict a kid. You can evict a kid's parent. So like, now their parent has lost their home or their lease. The kid is in and out of juvie. They have been kicked out of school. Like, they're in juvie. They're making friends there. They're learning. Like, this is apparently, no matter what I do, I'm going to end up going back to jail. So whatever.
Might as well just go fully down this road.
And not only is it bad policy, it's asking police to do things that I think we would all agree are not within the traditional scope of what we expect police to be doing. I mean, to take your point, sure, these were kids who might have had some, legal infractions in their past, very small ones, but there are always going to be constitutional limitations on the powers of police when it comes to how they want to handle any of those people. You cannot go on someone's property without a warrant or reasonable suspicion that they've committed a crime or done something wrong. If you do, there are a very narrow set of circumstances that the Supreme Court has recognized which govern those interactions. And when someone wants one of those interactions to end, generally speaking, the police have to abide by that request. They have to leave the property. They weren't doing that here. They were harassing people time and time again, and that's what gave rise. We had several claims, but that's what gave rise to the Fourth Amendment claim that we brought.
You know, and there was even, I want to even say, like, some of the higher ups, not the sheriff himself, but when we deposed them, some of the higher ups, when they were under oath, admitted like there were serious problems with this program.
Well, sure.
It didn't work. It was counterproductive. The community was growing to hate them. They couldn't trust them. Like, this is not good police work. Everyone supports good police work. And honestly, the better cops or the better sheriffs in that department, they knew this isn't what they signed up to do. They didn't want to harass 14-year-olds. They want to solve crimes and like protect people.
Well, and it's also hard to see the connection between, let's say, a 14-year-old who had an arrest for weed possession and code inspectors coming to, give you citations for having an overgrown lawn, and not give the child the citation, obviously, but the parent. And so now you have parents that are getting wrapped up in this in a way that's not at all related to what the underlying, criminal event was that presumably led them to being put on the list in the first place. And I think that one of our clients falls into that boat. Could you tell us a little bit about him?
That's a great point and excellent issue spotting on your part. That was one of our claims. Is guilt is specific to
You should be a lawyer.
Yeah, you really should be.
Thankfully, I picked the right career.
You can't punish one person
right.
for the misdeeds of another, and that happened not just with one of our clients, but it happened with 3 of them.
Oh, wow.
All 3. So we had 4 clients in the case, 3 of whom were parents of kids who were wrapped up in this system, and all 3 of those parents, in one way or another, whether it was code violations, arrests, or code violations and arrests, but all of them were subject to this type of heavy-handed enforcement that we've been talking about, strictly as a result of their kid having been on the list. Police would not have been coming to the house were it not for the fact that their kids were on these lists, and all of the consequences that they endured as a result of the kids being on the list are things that we challenged as violating the Constitution.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to further support our work, consider visiting ij.org/employer-match to see if your company participates in corporate matching. Every match dollar goes further to protect the rights of IJ clients nationwide. Multiply the power of your contribution today. Visit ij.org/employer-match to get started.
So can you talk a little bit more about, you kind of already have started down this, but can you talk a bit more about like the Fourth Amendment claims, this sort of guilt by association claim? Like, how did we structure this lawsuit?
So we brought 4 claims primarily, and we talked a little bit about the guilt by association, but it's what I just described. You have a freedom of association that's protected by the First Amendment. You have a right to be free from unreasonable searches and seizures, that's protected by the Fourth Amendment. And you have a right to be free from, arbitrary and oppressive conduct from the government, which is protected by the 14th Amendment. So we brought all these claims together, and we made it past the motion to dismiss on nearly all of our claims. We got it past a summary judgment, and we were headed toward trial. And I don't know if we want to talk a little bit about trial now.
Well, first, you'd say, we got past the MTD, we got through summary judgment. That in and of itself was a years-long, very convoluted road.
So it took about 3 years for us to go from filing the case to the eve of trial. And I shouldn't give short shrift to the accomplishments of the case team in even making it that far. Similar claims brought in federal court have failed, but between, I think, the strength of our advocacy and the misbehavior, the outrageous misbehavior of the defendants in this case, we were able to survive those obstacles and get us to a position where we were ready to try the case.
Ari's being modest because he was on the trial from the beginning. I joined for trial, and I saw the amount of work that they did to survive and what it took, the number of documents, the hundreds and thousands of hours of video. So he's being modest. It was a Herculean achievement.
So you came in, after he did 3 years of work, and you show up for a trial.
That's all I do. That was really the
Will
point.
is the trial specialist.
Right.
He loves the trial.
So I think we need to talk about this trial, though, because it's the trial that never was.
We should ever talk
right?
about.
And so how did this case ultimately resolve?
We were ready for trial. The eve of, we're just getting ready. Can't wait to swear in some witnesses, and the city gave up.
So what did that look like?
They admitted that they violated the Constitution in 3 ways on paper. I don't want to say they swore they would never do that again, because that's meaningless. They accepted a court order that says if they do this again, the court will go after them, essentially, and they agreed to pay our clients money. They completely gave up.
Is a judicially enforceable settlement agreement.
I mean, that's
we can
complete
haul
and
them
total
back.
victory.
Complete and total victory. If they ever do anything like this again, we can haul them back into court and have the court enforce the settlement agreement against them.
So what was it about, I don't know, Ari, Will, what was it about the eve of trial that suddenly made them capitulate?
I think when you're sitting there and you're ready to swear in witnesses and you're ready to really put it all on the stand, like I said, they put this stuff down in writing. They said, I'm proud of evicting mothers for their children. They had hours of videotape where they're saying, like, hey, if you rat on your kid, we can help you with the code citations. There's hours of videos of them going on to people's property. Like, there's just video of all of it and paper of all of it. Like, what are you going to do? At some point, there is only so much you can do to argue that they did not violate the Constitution. And I think they realized that the best case scenario for them was losing on 1 or 2 of our claims, and it was better to not fight for 3 weeks and just give up when there was. And go ahead.
Yeah, I'll just add to that a kind word about our trial team, because Will accused me of being humble before, and now I'm going to do the same thing.
It's the only reason I did it.
I think there were. I think everything he said is correct, and I think on top of that, the evidence I think was going to be devastating for the other side. Obviously, I'm biased, but we were very excited to get this evidence in front of the judge with a formal weeks-long presentation that was well thought out and well planned, and was going to be presented by some very, very talented advocates, both in the courtroom and then, given some of the resources that we were, fortunate enough to be able to devote to the case, we had a lot of people behind the scenes too who were going to be assisting us with this, and it was going to be a massive team effort. And it was just really, really encouraging and affirming to get into some of those pre-trial conferences with the other side. And, I won't speculate, as to how the other lawyers felt, but I do think at least we felt like we had an immense strategic and manpower advantage. And that's a really good place to be in on the eve of trial. And rather than take their chances, they dodged us for 3 years without ever having to meet on the battlefield. And then when the time came for the showdown, they understandably got cold feet.
I think one side, was clear that we were looking forward to it and we're going to have fun with this trial. And I don't know that they felt the same.
Yeah.
I mean, it's hard to get excited about, defending something that's so obviously wrong and disgusting.
As a pure legal take, that's 100% right. Like, you're going to have to go into court and defend something that's abhorrent.
Right.
And not just that, the optics of it too, and that's one of the kind of strange disconnects about this case, because, Will, you talked about how these officers in writing would brag about how many people that they evicted and would really get excited about that conduct. But when we published video of some of that body cam footage showing them doing those things, they got upset and they actually tried to get us to take those videos down. Am I right?
They did. This was our essentially our case launch video, where we incorporated a lot of the more egregious body cam footage that we had, and we got an email from their lawyer, who, to his credit, I think knew he couldn't tell us to take it down, but he asked us politely to do it. And we said no. And his explanation for why he wanted it to come down was, this is reflecting very poorly on our department. And our view was, if you don't want people to be upset with you, then don't do horrific things. And the comments on the video were not anything that we were super concerned about. It's not like there were any actual concerns with any sort of response toward the sheriff's department itself. So we obviously didn't take it down. Going back to the trial, though, I do want to add one thing, because I think we'd be remiss if we didn't offer the other side's explanation for why they didn't try the case. We're up here just talking about how awesome it was going to be for us to get into court against them. They have said after the settlement was made public, that this was a purely financial consideration. that trying this case over a period of weeks was going to be very costly. And basically, as responsible stewards of their taxpayers' money, they were going to not try the case. They'd pay us money to go away, and they wouldn't have to pay millions of dollars in attorney's fees. They didn't explain why.
It took all the way to the day before trial.
They paid those bills for 3 years.
About to say, 3 years of attorney's fees is not cheap.
Nope.
No.
They paid those bills for 3 years, but suddenly they had to tighten the purse strings.
Yeah, and not when trial got scheduled, but they still did all of the prep, and
It's literally the night before.
Yeah, but I mean, fair enough, saving some money for the city. Okay, I'll take it. Did the settlement ever include an apology? Like they admitted, hey, this stuff was unconstitutional, but is there any sort of contrition here?
I don't think that they understand what the word sorry means. I don't think that would have been a line in the sand worth going for, but I will tell you one of their early lines in the sand was they wanted to insist on confidentiality in the settlement. And of course, that means we can't, had we agreed to that, we couldn't do podcasts like this or talk about how absolutely terrible the sheriff in that program was. So you can guess we probably weren't going to agree to that one.
Well, I think this is something I kind of expected us to talk about a bit later on, but this is maybe a good time to talk about it the point of doing sort of an IJ style lawsuit is to set precedent that has this impact and that kind of, can be applied in other situations and things like that. It's not just about, the specific clients and the specific situation, but it's kind of creating this broader thing. And, in this case, the settlement sort of does that because it sends this strong signal of, hey, other cities that are looking at Pasco's situation and seeing, oh, you're doing this new creative thing. Should we start adopting that sort of system? This is a pretty clear, no, do not do that. People will sue you and then judges will be mad.
Their system was so bad. It was like a cancer that was ready to metastasize. And the nicest part about the settlement is the next sheriff that Googles predictive policing, the first thing that should pop up is had to admit they were wrong and they violated the Constitution. It's not just a court decided at this point, the sheriff had to admit he was wrong and will continue to do so. And has a court, a judicially enforceable agreement not to do anything like this ever again. It sends the clear message that do not even think about trying this.
It would have been fantastic to get this case all the way to the U.S. Supreme Court and have this amazing decision declaring this policy unconstitutional in the way that they implemented it nationwide for all time. And that's why we typically don't settle cases. But at the end of the day, I mean, we're lawyers and we have clients whose interests we represent, and we can't forget that. But for the most part, we don't ever find ourselves representing clients who want to settle cases.
Sure.
And so we don't have to worry too much about a case going away before it reaches the level of the appellate level that we hope to get it to. This was a unique case in a lot of circumstances. And it was unique in that we settled it, but we settled it in the way that we settle any case that we ultimately become willing to settle, which is our clients basically said, we're not going to settle this unless we get everything that we could conceivably get if
through
we just
court.
win it.
Yeah.
Right.
And in this scenario, I think we actually got more than we perhaps could have gotten, especially in terms of the monetary damages that ultimately ended up going to our clients.
And to our clients' credit, they weren't even willing or interested in talking or negotiating about money unless and until the city agreed to write down that they violated the Constitution.
I'm hoping to get out of this lawsuit justice. I want the policy to end. Nobody should be going through this.
And I guess in a way this, without being lawyers, the way I can contribute. And I think that's my job.
So it wasn't even until the sheriff just accepted responsibility that we even negotiated on
and
money.
Yet, to your question earlier about whether he apologized or there was any reflection of contrition, in that same statement where they talked about how this was purely a financial decision, they did the opposite of apologizing, which was to say, we're not sorry.
Hashtag no regrets.
Yeah, we would.
Sorry, not sorry.
We were trying to protect the people of Pasco County by harassing these citizens, evidently, and the only reason why we're entering into this settlement agreement, even though we're acknowledging we violated the Constitution, is, like I said, because they didn't want to incur the cost of defending it in court.
Yeah, I mean, Keith brought up Minority Report earlier, and I think that's kind of an important thing to remember here is, yeah, it's fair enough for police to enforce laws and to to, stop crime that is actively happening, right? But this is very much a pre-crime situation. And it is based sort of on this theory, and you, Ari, I think mentioned earlier that one of the sort of experts or something in the case is the person who kind of invented the theory behind this algorithm, and then they ended up volunteering to be a witness on our side, if I recall. And so sort of how did that even come about?
So there are a number of different labels that have gotten applied to this approach to policing, whether you call it like predictive policing a la Minority Report, whether you call it what the sheriff's office called it, which was intelligence-led policing, or whether you call it what the founder of this generalized theory calls it, which is focused deterrence. I don't want to misrepresent him, but I think one thing that he would want us to make sure we say very, very clearly is that what the sheriff's office was doing was in no way what he had in mind when he devised this theory of policing, and was in fact not at all an accurate reflection of the theory that he came to call focused deterrence. That was designed primarily for dealing with violent urban environments, and how do you stop one shooting from leading to another shooting from leading to another shooting. It was never devised to go after 14 and 15-year-olds who had been accused of breaking into a car, and it was never intended to justify constant and continuous police harassment and harassment of their parents. And he was so disturbed when he found out about the fact, when he learned that they were using his work and his research to justify what they were doing, that he actually reached out to us. And that's what started the process. But he was deeply disturbed to hear about what they were doing. He was even more disturbed to learn they were doing it, they said, based on the research that he had conducted. And he was indispensable to our ultimate success in the case.
He's incredible. And I will not be able to explain it nearly as well as he did, but he was talking about, like, the idea was you go to, let's use gangs as an example, and be like, we're aware of who you are. We, the police, we're watching. If there's a shooting or if there's some sort of major event, like, we will bring the full force of the police department down on you, which makes sense and strikes me as good policing. And he calls that focused deterrence, making sure people know that they are being watched. He said this was such a bastardization of his work because it neither was focused, did not deter. No one knew they were on the list. There was no notice, which is number one. You're supposed to know that there's going to be consequences. They didn't wait for you to commit a crime. They just picked literally young kids on the list and just harassed them and created new crimes that they brought the full force down on. And that there was no like alternative. There was no way to be like, hey, here's the option. Like, you can commit these crimes and you know that we know where you are and we're going to arrest you, or we can work together to get you other resources. He was so upset, and to hear him explain it he's very deserving of respect.
So you guys have mentioned, sort of the compensatory damages. I don't know if that's quite the right word, that the clients received for what they endured. Can you talk a little bit about sort of, what that experience was like for them going through all of this?
Absolutely. I mean, if we're being completely honest, there's no amount of money that could probably make them whole, given what their experiences were. If you take Robert, for example, Robert was issued code enforcement violations that he never received notice of. So he missed court dates, which resulted in his arrest. He closed the door on the police. They then sat outside his home figuring out how they were going to get him, what they were going to do to him, what they could arrest him for. So they then, once they figured out what it was, they pulled him out of his house and arrested him for that. Robert was arrested multiple times. Tammy was arrested multiple times. Tammy is now a convicted felon as a result of having to take a plea deal while she was awaiting trial for months and months while, awaiting that trial date in county jail. So it's impossible to overstate both the emotional stress that they endured, and then a lot of the real world consequences that flow from having been arrested that many times, from having become a convicted felon, whether it's incurring massive amounts in legal fees to pay for a legal defense, or being unable to get a job or employment after the fact. These are scars that are going to be with them for the rest of their lives. I'm overjoyed for them that they were able to get a little bit of compensation out of this. But if we're being completely honest, there's no amount of money that they could really ever get to make them whole, like I said. And I think that's part of why they were so adamant when it came time to settle the case, that there would be no settlement and no discussion of money unless and until the sheriff's office was willing to commit in writing to having done something wrong.
And what was the reaction when the sheriff's office finally agreed to do that?
I think it was relief, jubilation. I can't speak for them, and that's because it's such a personal experience and given what they endured. But in many respects, it's sort of they're fighting for their kids. They wanted to make sure that other kids don't end up getting caught up in systems like this. And then they were also fighting for themselves and trying to make right what they had endured. And so I think there was a lot of emotion, and I think it was very cathartic for them. It's vindicating, it's validating, and it's a payoff for their courageousness. The sheriff's office was a very big bully, and they weren't the only people we talked to when we were working up this case, but they were the only people who were willing to stick their necks out to be clients. And I think a lot needs to be said for all of our clients, but especially in a case like this one. There was legitimate fear of retribution and abuse from this sheriff's office.
Whenever we run out and try to bring back dinner or something, the kids are getting bangs on the door, and these officers are wanting to talk to my kids too. And my kids don't know any more than we do. Every single time I try to give a little bit to you guys, I end up with this. And it's even 10 times worse than it started out at.
Man, listen, we don't have time for your games. You're an idiot. You're inside of a house. Aren't you being detained, moron?
Yeah, you're fat and ugly. Shut the hell up.
Hey, let's stir something up with this.
So with what?
Whatever you saw, which is police talk for they're a bunch of fucking assholes.
Hey, last time we made her cry.
Mom?
Yeah.
Yeah, I mean, the specter of sort of, the government is going to retaliate against you for fighting back kind of hangs in the background of all of our cases. But here, the government is already, actively
Feels
harassing
a lot more
you.
real, doesn't it?
Yeah, and so it's perfectly easy to imagine, hey, I've already been arrested in front of my kids just for, having grass or whatever. That, now if I start making a stink about this, it's, the hand is going to come down even harder.
And they almost to a person said, that expressed that I think one of the most unsettling things is that when you're the subject of some sort of abuse, whether it's at the hands of the government or a private party, like in the back of your mind, that there is this entity that's out there to protect you, and it's the police. And in this case, the abuse that they were suffering and the harassment they were suffering, this wasn't, a bureaucrat in an occupational licensing office. It was the people who are sworn to protect and serve. And I think that was, really troubling for them as they made their way through this process. But I think ultimately the outcome was very validating.
To sort of wrap up, how will this victory affect the future of technology in policing? I mean, Pasco's algorithm, such that you can call it, is pretty crude, but we've seen other examples of kind of more high-tech policing situations. And so what happens from here?
I think there are going to be a lot of complex questions that we need to answer, but I think we're always going to be starting from a place of some elementary principles. The Constitution provides limitations on the power of government when it comes to its ability to do certain things, including policing. We have a Fourth Amendment. We've had it for a really long time. The courts are constantly interpreting it, and that interpretation is going to have to adapt to our times, as it always has done. But I think here we've got a set of really concrete principles. And even as the algorithms get more sophisticated and the list generation maybe gets a little bit more complex, it's nonetheless going to be the same in terms of, well, what can government do with that data? There's definitely going to be a lot of debate and litigation over data collection. But on the question of what can government do with the data, the answer to that question is always going to be answered by the Fourth Amendment. And it was answered by the Fourth Amendment in this case, or would have been if we didn't get to the settlement.
Well, thanks so much for coming in, guys.
Thanks for having us.
Yeah, glad to be here.
Thanks again for watching. Make sure to like, subscribe, and tune in for more videos.